Chapter 9 of Alteration and Cancellation of a Bond. If a bond, after its execution, be altered by the obligee in a material part, either by rash interlineation, addition, or drawing a line through the words, whether the original writing be legible or not, it will be void at common law. But an alteration by the obligor will not destroy the bond, for a party cannot take advantage of his own wrong. So it would seem in the present day an alteration by a stranger in a material part would not avoid the bond, provided the contents of it could be proved. If the alteration be made in an immaterial part, the obligation will not be affected by it. Where the bond was conditioned for payment of £100 by 6 equal payments of £16, 13s. 4d, on a certain day in every year, until the full sum of £1 was paid, and a person, in whose custody the bond was kept, without the knowledge of either party, inserted the word hundred between £1 and £, the alteration was held immaterial. So if a blank space be left for a Christian name or addition, which is filled up after the execution of the bond, with the assent of the parties, the alteration will not affect the validity of the bond. And where two persons executed a bond, and afterwards the name and addition of another was interlined, and he also sealed and delivered the bond, with the consent of all parties, it was held to be the bond of all three. Also where a party executed a bond, with blank spaces for the name and sum, and sent an agent to raise money on it, and the obligee having lent half the sum required, the agent accordingly filled up the blanks with the sum and the obligee's name, and delivered the bond to him, on plea of non est factum, the bond was considered well executed. But where, after the execution of a bond by two only of three joint and several obligors, the name of another obligor is substituted for the party who had not executed, without the knowledge of the obligors, it would seem the bond is void as against them, notwithstanding they have afterwards assented to the alteration and paid some instalments due on the bond. If a material alteration be made after the execution is perfected, though with the consent of all parties, a new stamp will be requisite. Before, however, the execution is perfected, any alteration may be made, as where another obligor was added to a bail bond after it had been executed by several others, but before the sheriff had accepted it. Such addition being made with the assent of the sheriff, was held not to vacate the bond or render a new stamp necessary. If the seal be broken off by accident, or by a stranger, or by the obligor, the bond will remain in force, on proof that it was sealed and delivered, and thus accidentally or wrongfully cancelled. But if the obligee tear off the seal with an intention to cancel the bond, the obligation will be destroyed, for though no deed, which has once passed an estate or interest, can be avoided by cancellation, yet it is otherwise with a bond, which is merely obligatory upon the person. And if the bond be joint, or joint and several, the tearing off the seal of one of the obligors will avoid it as to the rest, though if the bond be several only, the others are not thereby discharged. If an obligee deliver up a bond to the obligor to be cancelled, which the latter omits to do, and the bond again gets into the hands of the obligee, the obligation still remains in force at law, and the obligor can only obtain relief in equity.